I'm attorney John Mangan. I've been practicing law specifically in the area of trusts and estates for approximately 15 years. And during that period, I find that a lot of clients have questions for us about trust funding. What is it? How do you do it? When do you do it? That type of thing. So what I'd like to accomplish today is to just give you some answers to some of those common questions, fill in the gaps where maybe you know a little bit, but you don't have a full explanation. And just know that if you have any questions that this video does not address, you can always feel free to reach out to us. Okay, so first issue, what is trust funding? That term gets tossed around a lot, and it's not always readily apparent to a non-attorney what that entails. So basically, trust funding involves retitling assets. For example, let's say you own a bank account and it's got $100,000 in it. You've created a trust through the help of your attorney. And now you hear something about, oh, you need to fund your trust. Well, maybe yes, maybe no. We're going to get into more of that later in the video. But funding would just simply mean you go to the bank and you retitle that account. So it's no longer listed in your individual name. It's now listed in the name of your trust. Once that has happened, the trust funding specific to that account is complete. That's really all trust funding is. It's just retitling assets into the name of the trust. There are lots of assets that can be funded into trusts, real estate, bank accounts, investment accounts, etc. So the next question we often hear is, okay, I have a trust. Should I fund it? And the short answer is it depends. Make sure that you've received specific advice from your attorney. If that's our office, then we always provide guidance on what we recommend that our clients do. So we provide a nice letter to our clients when we're finishing up their estate planning work, just saying, hey, we recommend that you fund these assets into your trust. That's assuming that our office has not been engaged to do that work for the client, which we often do if they would like us to. So I'm just going to go through a few different assets and scenarios with you and explain where we would often recommend funding something or not funding something. So the first one is pretty straightforward. Automobiles. We generally do not recommend funding these into a trust for a couple of reasons. Number one, I've seen situations where auto insurance rates go through the roof if the auto is now owned in the name of the trust. Also could make you more of a target from a liability standpoint. The other thing is that if you pass away owning an automobile in your own name, and if everything else was in your trust, automobiles are honestly just about the easiest asset to administer following death. It does not necessarily mean that you have to go through probate. It's typically here in Florida a process of going down to the tax collector's office and signing some paperwork, attesting, for example, that there are no outstanding creditors, and presenting a certified copy of the will if there is one, and a death certificate. And they are then often able to just retitle the automobile into the name of the rightful heir. Let's talk about marital situation or status. So when we have single clients or clients that maybe are in a second marriage, we are more likely to advise funding assets into a trust. But on the other hand, if we have married clients, stable marriage, and often these are clients that have been married to each other for many, many years, in those situations, we often will recommend not funding joint assets into an account while the clients are married to each other. The reason for that is really twofold. Number one, if they are owned in the form that we generally recommend in those situations, which is tenants by the entirety, that has two main benefits. Number one, there are asset protection advantages associated with owning that asset as a married couple in the form of tenants by the entirety. Basically means if one spouse is sued, those assets owned as tenants by entirety are going to be exempt from the claims of that creditor, provided that the creditor doesn't have a claim against both spouses. If you just fund assets into a trust, you're going to no longer have the advantage of that protection. The other thing is with tenants by the entirety, those assets will automatically pass to the surviving spouse upon the first death so that no probate is necessary at that point. So, always follow the advice of your attorney, but in many marital situations, we recommend not funding the trust now. Subsequently, upon the first death, then it does become very important to fund assets into the trust. Let's talk a little bit about real estate. If it's homestead real estate, then the funding issue, the short answer again is it depends. There are strong reasons, both yes and no, as to whether to fund homestead property into a trust. But generally speaking, if you are married and or if you have minor children, it's generally not going to be a good idea to fund that homestead property into a trust because of some of the rules, the statutes, and even what we have in our Florida Constitution. It all plays into what happens to your homestead property upon death, regardless of whether you own it in your trust or not. Non-homestead real estate, in many cases, we do recommend putting this into a trust, especially if the property is located out of state. If you have out of state real estate and you pass away owning it in your individual name, that often requires sort of a double probate. We have to probate the property in the state where the real estate is located, and we have the primary probate here in the state of Florida. So double probate, generally not a good scenario. So if you own non-homestead real estate in an LLC or in your individual name, we often do recommend funding that into your trust. Now, there are some accounts that generally will pass according to the beneficiary designations that you may have set up with the financial institution. So life insurance is a great example. In most cases, unless we have created an irrevocable life insurance trust, we generally don't recommend changing the ownership of the policy. But what we do often recommend is changing the beneficiaries associated or named on that life insurance policy. So that's sort of when we think about funding with life insurance, outside of a situation where we have created an irrevocable life insurance trust, generally the funding, so to speak, is just updating the beneficiary designations. Other types of accounts where beneficiaries may need to be updated and potentially include a trust would be tax qualified accounts. So these are things like IRAs and 401ks. Like with life insurance, these pass according to the beneficiary designations that you have set up with the financial institution. We would almost never recommend changing the ownership of these accounts to put them into a trust. Rarely ever would we recommend that. However, again, we often do recommend updating beneficiaries, and we may recommend naming a trust or a sub-trust that you've set up that would be triggered upon your death to be named as a beneficiary. Again, with our estate planning clients, if they're doing this funding component themselves, we give explicit instructions on how we recommend they do this, the exact titling or wording that they should use to name the right trust as beneficiary, if that's in fact what we are recommending. Now, there are some other types of assets, things like non-qualified investment accounts and bank accounts. With those accounts, we are going to be, if we're recommending funding, it's more typical funding where we're just changing the ownership on the account. Much like I described in the earlier example with the bank account, it's just a matter of updating the ownership on that account. And again, just as a reminder, just because you have a trust does not necessarily mean that the trust should necessarily be funded right now. That would be something that your attorney will guide you on. But if it's especially long time, stable marriage, in those situations, it may be best to wait to do the funding until after the first spouse has passed away. Okay, now you have guidance at this point, hopefully from your attorney, on what assets should be funded into the trust, if any. Let's assume you have assets that should be funded into the trust. Well, if we're talking about non-qualified accounts, bank, non-qualified investment accounts, again, those are ones where if you're doing the funding component yourself, you just simply contact the financial institution, tell them what you're looking to do, and they'll provide the forms that are necessary to accomplish the funding. Understand that each financial institution is going to have their own proprietary forms. So there's not just one form that any attorney could give you. You're going to have to obtain this from the relevant financial institution. Likewise, with life insurance and any tax qualified accounts, you'll need to contact the institution. Difference here is that unless we've created an irrevocable life insurance trust for you, you're probably just updating beneficiaries on those accounts. And you just request, hey, what do I need to do to update the beneficiaries? Please send me those forms, and they can easily provide those to you. If you are funding any real property into your trust, that's something where we highly recommend that you allow the attorney to do it for you. If you own the real estate in your individual name and we're moving it over into the trust, that's going to require a deed. If you already own the real estate through an entity like an LLC or a corporation, the attorney can prepare an assignment for you so that you can move that ownership interest over into your trust. So I hope you found this video helpful. Again, it's really just designed to be an overview for you of the trust funding process and to answer a lot of the common questions that we often get from our clients. Number one thing to take away is please always follow the advice of your attorney on whether to fund assets into the trust, and if so, which assets to actually fund. Your attorney can give you specific guidance with answers to those questions. If you have any additional questions, please feel free to reach out to us. We look forward to hearing from you.